Number 128, matter of the Friends of PS 163 versus Jewish Home Life Care Council.
Good afternoon, and may it please the Court. Matt Shahabian for the Friends of PS 163 appellants. Your Honor, may I reserve 2 minutes for rebuttal?
You may, sir.
The Department of Health failed to take a hard look at two critical environmental impacts on students at PS 163, construction noise and lead dust. For noise, the department relied on a made-up 2 years of noise rule to avoid evaluating the impact noise would have on PS 163 students and whether those impacts could be mitigated.
Well, I'm a little confused by that argument because didn't they nevertheless do an actual study?
They did the first step.
And I thought your argument is that, you know, they've got this 2-year durational standard that shouldn't have been applied and that taints everything else. But the fact of the matter is they did do a study.
That was just step one in the process. So step one is to conduct the assessment and actually measure how much noise is going to be expected at the school. Once that analysis was complete, the noise the department measured will exceed the 45 decibel significance threshold in the seeker manual. At that point, because it was significant, it should have been mitigated. That's where the department...
Didn't they require some mitigation measures? Several mitigation measures, maybe not exactly what you had wanted them to, but they certainly did employ some measures.
So there were no initial measures required specifically to mitigate below the 45 decibel threshold in the initial draft statement. JHL proposed installing soundproofing windows and window units to PS 163 after we raised these issues in the comment period. But because the department relied on this 2-year noise rule to avoid actually evaluating the impacts expected...
But doesn't this boil down to wanting on the noise side, you want the central air conditioning? Isn't that the crux of the argument?
At the end of the analysis, yes. So our expert...
Okay, but then isn't it within the agency's authority to decide when it has a choice of how to mitigate what measures to adopt? And aren't we limited in trying to force upon them something that you might think is better?
So what this court said in Jackson is where the analysis is properly conducted, where there is actually a hard look taken at the impacts, it will not require an agency to choose between mitigation measures. And so, for example, in Jackson, the issue was secondary displacement effects on people living in the Times Square area. The agency looked at the issues, decided the mitigation efforts were anti-harassment laws for tenants. The petitioners wanted a fund that would help the tenants relocate. And the court said, well, the agency took a hard look at the issue, and at the stage of which mitigation measure is better suited to this, we're going to defer to the agency. But because the failure here started at the reliance on a 2 years of noise rule, there was no hard look that could be relied on to pick a proper mitigation.
But are there, I'm sorry, I'm misunderstanding that. Are there conclusions based on their assessment that it's less or more than 2 years? I'm really not clear. I thought they actually looked at what the decibels would be, what the impact would be. Again, you know, the department didn't agree with you on central air conditioning, but they did make those assessments.
So I have two answers to that question, Judge Rivera. On the first step, the department reported what the measured impacts would be, but it repeatedly said throughout the statement process that because noise would not exceed a 2-year threshold, it was not significant under the technical manual criteria and need not be evaluated for mitigation.
But they looked at, I thought they looked at the certain periods in which it would in fact exceed the threshold and implemented some additional measures, such as certain work not taking place during certain times and things like that. So, I mean, my impression was that they, even though they thought, as Judge Rivera indicated, even though they thought that may have thought that the 2-year rule was in place, they nevertheless did things to mitigate when the noise level would exceed.
So I do not dispute that there were some mitigation proposals adopted here. However, in the department's assessment, they were unnecessary. They were not required because of the 2-year rule. And even under that analysis, because
But then what does it matter? If they're requiring the mitigation, but they're doing more than is necessary, I'm still confused. What does it matter if they got that 2-year durational criteria wrong?
It matters because the proper criteria is will noise exceed 45 decibels, and it will still do that here. Even with the mitigation proposals that were adopted, even on the department's analysis, it is undisputed that noise will reach levels.
Isn't your argument really, you're not asking us, as I understand it, on noise for a de novo review of the factual determination of the validity of the mitigation measures. Instead, you're saying that this two-year rule is what makes this a legal error. Isn't that the core of it?
That's correct, Your Honor.
All right. So that being the case, now, am I right that the traffic levels or the noise levels here were comparable to the noise levels in the heavily traveled New York City street?
That's correct, Your Honor. It would exceed that 45 decibel threshold and reach those
Well, I
levels.
suppose the argument is if it does it for 23 months, but not 24 months, that seems to be arbitrary and capricious. I suppose that's the core of it.
And that is why it was flawed to rely on this two-year rule. That's right.
I see. Okay. All right. Because, you know, I live in Buffalo, but New York City streets always seem kind of noisy to me. You know, it's not that there aren't, but when you compare them, so I suppose there's some validity to that argument. The problem with it is, I think, is that is the suggestion that there's a mitigation measure that we should be looking at, and I'm wondering if that's beyond our powers to do that kind of review.
So it's not beyond the court's power to actually look at whether a hard look was taken at mitigation measures, because SECRA has a substantive requirement that the agency mitigate environmental impacts to the greatest extent practical. That's reviewable under this court's power. All this court has said in cases like Jackson is where there is a hard look, where the analysis is properly conducted, and there's a choice of various mitigation efforts that would each be tailored to that impact, the court's not going to interfere in the policy decision to choose among the impacts. But that requires a proper analysis be conducted in the first place.
Thank you, counsel.
Thank you, Your Honor.
Counsel?
Good afternoon, Your Honors. John Lobert for the Wright petitioners. The Department of Health admits that soil that would be disturbed by the proposed project would contain elevated levels of lead and potentially increase exposure pathways, but they never analyzed those pathways as they pertain to this site, to the children, or to the neighbors. Their chapter on mitigation doesn't mention lead dust. I'd just like to highlight...
But counsel, I'm sorry, in that analysis, though, aren't they looking at whether the lead dust can move from the site to other areas, which would include the school?
Well, they did not look at that, actually, Your Honor.
But aren't there mitigation measures aimed at containing the lead dust on the site, like putting topsoil down or watering or whatever they are? Aren't those measures at containment?
Well, they did undertake to spray water on the site as is required by a generic, by the generic construction plan that they adopted, but they didn't do any evaluation of how lead dust might travel to affect the children or the neighbors. And if I may, the reason they didn't is that no fewer than 18 times they repeat that the test results don't indicate a soil lead hazard as defined by US EPA, and that, quote, the site does not pose a significant threat to public health or the environment based on the lead concentrations present.
But they said they followed the federal rules about lead dust, and those rules, as I understand it, are aimed at protecting vulnerable populations such as children and the elderly. So if they complied with those rules, why is that not reasonable?
Well, first of all, the federal rule at issue is the National Ambient Air Quality Standard for lead, which has to do with, which concededly does not apply to dust that's transported to another location and deposited over time. It applies to inhalation over a short time period.
Okay, so you would agree then that at least as to inhalation, that's rational?
No, I would not, Your Honor, because the fundamental basis of our challenge is that the test results were manipulated, they were disingenuously presented with the intent.
But that brings me to a more macro question, which is, what's our role in this vis-a-vis the appellate division versus the trial court, or the motion court, I should say, and in terms of standard of review?
Yes, well, I think this court can look at whether the decision reached was arbitrary and capricious. In this context, that means looking at whether the respondents took a hard look at the environmental hazards that they concede are present.
Does
If
that
they
include-
manipulated
does that
the test
include our-
results.
Right, and so that's where, exactly where I was going to ask you. Do we have, for example, are you asking us to look at whether the test results were manipulated and decide that to determine that a hard look was not taken?
Yes, I am, and I think in this case it is so obvious. I mean, JHL takes the position that under no circumstances can you look inside that black box. I submit that that cannot be the law, that they included in concluding that the soil did not pose a lead hazard under the federal standards. They used, of the 38 samples they used, 16 of those were samples that they themselves said they weren't going to use, that shouldn't be used, and that were contrary not only to state guidelines, but also to the Seeker technical manual. This isn't in our brief, but I did alert respondents 2 days ago that I was going to refer to page 12-7 of the Seeker technical manual. So it's against state guidance, it's against the technical manual, and it's against their own statement of what they said they did. So they said they took these 16 samples to look at how the waste should be disposed of, and then they took other samples to look at whether the site was hazardous. But instead, when they found that the average didn't come out like they wanted it to, they added these 16 samples in to bring it down below the federal soil lead hazard level.
Counsel, were there any recommendations made by the petitioners that weren't addressed?
Yes. Well, tenting the site was only addressed in response to a comment in which basically the response was, well, there's no real hazard here, so we don't have to do it. And that was what they said no fewer than 18 times in the FEIS and the finding statement, that the reason they didn't have to do anything further with respect to lead dust was that the soil on the site did not present a lead hazard. And I would submit that...
Council, as have already been pointed out, they did take measures. The sprinkling of the water, the
Yes.
covering of the trucks, the cleaning off. So I think it does boil down to whether or not they give you the tent. So what you want is full containment, because as I understood the argument here, it's that you disagree with the government as to whether or not there really is an acceptable level of lead dust.
We say they
that
should...
anyone could breathe in, especially the children.
Yes. We say they should have considered that. They didn't consider it, other than to dismiss it in a comment, in a response to a comment.
So the cutoff, the work cutoff that's been, that's part of the mitigation required, as I understood it, it was if the dust levels were between 100 and 150 parts per million, which is 250 below the, I think the EPA guidelines, I'm not sure. Is that correct? Do you understand it that way? That there's a work cutoff when the dust levels
yes.
exceed a certain level?
Yes.
And that cutoff level is substantially below the 400 parts per million, which is the accepted level.
No, Your Honor.
Okay.
The cutoff level for, you mean for when they're going to stop work?
Right.
So their whole calculation on that, as an input, it takes the average soil, the average level of lead in the soil on this site as an input into that calculation. And because they didn't treat the data appropriately, their average, which they say is 290 parts per million, it's actually above the federal soil hazard level. It's 488 parts per million. So if you had input that, you would come out with a different result on the air quality as well. And can I just make one very brief additional point?
You may.
So, no, yes? Okay. I just wanted to point your honors to the two letters from the Department of Environmental Conservation that they cite 10 times as saying that the soil is fine. And in the first of those letters, DEC said that only 1 of 38 soil samples exceeded the federal standard. Then they were informed of their mistake that 25 of the 38 actually exceeded, so they came back with a second letter in which they moved the goalposts. They said, oh, well, whereas before they'd said, oh, we're going to make you comply with the highest cleanup standard, 63 parts per million. So now they say, oh, no, the applicable standard is 1,000 parts per million. And which is the standard applicable to a commercial land use, and they say it's applicable here, but if you look at their own regulations, the DEC rules say this standard shall only be considered for land whose primary purpose is buying, selling, or trading of merchandise or services, and that cites in our brief.
Thank you, counsel.
Thank you.
Counsel?
May it please the court, Esther Merdukaeva for the state respondents. I'd like to start with the noise analysis. The petitioners are incorrect in stating that DOH disregarded the impact of noise on the students at PS 163 and that DOH disregarded the impact that the noise level after mitigation would have. I'd like to address one of Judge Fahey's questions first. You had asked whether the noise would reach the levels of traffic on a street.
Heavily traveled New York City street.
That would be the noise on the outside of the building. On the inside of the building, the noise would be well under the 45 decibel threshold that the CEQR sets for school classrooms. Occasionally, that noise level would rise into the low 50s.
Well, that's when you get into the open window and closed window problem, right?
That's correct, but just to finish my prior answer, the low 50s number is equivalent to background noise in a quiet office or to the sound of moderate rainfall. So on the intermittent occasions that the noise level would exceed 45 decibels, it would not be equivalent to a trafficked street. It would be equivalent to an office. And DOH
But they say the only way to properly ventilate this building is to keep these windows open, so
That-
aren't you back to this external sound? The noise that's external is really the level you have to measure?
No, Your
the
Honor.
impact?
No, Your Honor. The petitioners do claim that it is impossible to leave the windows closed and use the window air conditioning units in the classrooms, but they don't actually provide any empirical data to support that assertion. They claim that ordinarily they have to leave the windows open because the window air conditioning units don't work. But DOH evaluated the standards in the classroom and the situation in the classroom and determined that the window units,
Well,
which have been...
How'd you do that?
Well, the window units have been in place in the school for decades. The
No,
noise,
that's already a problem, but how did you confirm what they argue, which is, it's an old building, we got to open all the windows to circulate the air. And what more can they do but tell you that's the case? So what did you do to confirm or to see whether or not the building could function with all the windows closed? Because
Well-
I understood the mitigation with the air conditioners, there's other mitigation, but with the air conditioners you just said, we'll give you more window air conditioners. Just keep your windows closed and we'll give you more air conditioners. And they've said, that's what we have now and it doesn't work.
well, Your Honor, they could have provided empirical data to support that assertion, and they did not. They also
I'm sorry, would have been what?
would have been...
Since it's your burden, right, to do this, to do the secret evaluation, right?
It is our burden to do the seeker evaluation, but DOH reasonably concluded that because the window units had been in use at the school for years, and because the windows could be left open during times that construction is not happening, which is the early morning, late afternoon, and early evening, that those two measures combined would provide adequate ventilation.
Was there an analysis of whether or not, now I'm going to go to lead, the migratory lead dust, if indeed they would have to open the windows at other times for these periods of time, if indeed that meant that lead dust would migrate into the classrooms?
No, Your Honor, and that is because of the mitigation measures that DOH imposed with respect to the lead dust. And DOH concluded that those mitigation measures would most likely eliminate all risk of lead dust, or at a minimum.
Can I ask you about those for a second?
Yes.
The mitigation measures, you rejected the tent proposal, is that correct?
Yes.
Do you know of any instances, I couldn't find any, so you may know of, where it's either been, as part of a secret review, it's either been suggested or required that a sealed tent was put over a full construction site?
No, Your Honor, we're not aware of any such instances. And in fact, the CEQR manual, which governs environmental reviews in the city, does not contemplate a tent.
So nowhere within the city itself, how about anywhere else in the state?
I'm not aware if it's required anywhere else in the state. The petitioners have not cited.
The reason I ask is I was particularly interested, I wanted to know what kind of settings. For instance, would a sealed tent be required, perhaps if you're mitigating possible environmental exposure, in the context of children being close or a heavily packed urban environment as opposed to a more rural or a more spacious environment? I just didn't know.
Certainly, but the fact that it's not required in the city's CEQR manual is actually quite illustrative here. The petitioners also have cited no industry standard and no agency guideline that requires.
I'm sorry. Could I ask a more general statement about this? Because a lot of this seems to focus, the way we get to whether the tent is necessary or not has to do with how the samples were taken and how the arithmetic was done, if you will. Okay, and so I assume you would agree with me that although we have a deferential standard of review, it still has to be meaningful.
That's
Okay,
right,
so,
yes.
So what if they went around this property and they figured out areas where there was no lead contamination and they took the soils only from those areas, okay? And then they said, oh, there's no lead problem here. You would agree with me that would be irrational. That would, okay?
If there was
Right.
any evidence of that, that might be irrational.
So
That's
how
right.
do we, what is our role in determining at what point that their methodology went from being arbitrary and, or from being rational and reasonable to being arbitrary and capricious? How do we do that? And should we do that here?
The rule of reason applies to an agency's reliance on an expert report, and I would be happy to explain how that sampling protocol was developed. The sampling protocol itself is on pages 3005 to 3014 of the record, and at page 3771 of the record, DOH further explains some of the methodological choices that it had made. There are no standards for the number of samples that have to be taken in a particular site. This site is about 3/4 of an acre, and the number of samples that was taken was derived from the total number of cubic feet of soil that would be excavated.
How about where on that 3/4 of an acre?
The location was selected in consultation with DOH and DASNY, which was assisting DOH in this process, and the locations were selected to be in the areas of the footprint of the building, because that was the soil that was most likely to be excavated.
So you're saying as long as it wasn't randomly done or done without any basis or any expert advice, then it's okay?
That's right, as long as the agency reasonably explains the methodological choices that the study it relied on
Could you
made.
respond to, I think the petitioner's expert said that he questioned the methodology and had never seen anything like it in over 30 years.
The petitioner's expert did say that, but notably, the petitioner's expert did not state a number of samples that would have been appropriate to take. They have identified no standards about the number of samples that would be
I
appropriate
didn't think it was
to
so
take.
much the numbers, but using the same site to take the test borings from over. I thought it was more of a situation like that.
Well, my understanding is that they have two complaints. One is about the number of samples that were taken of shallow soil and about the
see.
use of the tree pit samples. And with respect to the tree pit samples, the CEQR manual expressly requires shallow soil samples to be taken. These are shallow soil samples on the location of the site that will be excavated.
Let me ask you this, is there any science to indicate that there would be a portion of this property, if there's indeed lead and hazardous waste and so forth that would not have been contaminated? That is to say, where would you look for something that's not contaminated if you've got hazardous material on this small lot?
My understanding is there's no way to
I
determine.
mean, it's soil-based,
It's
right?
soil-based, and DOH explained that the way lead appears in soil is in log normal distributions, which means that some areas have a concentration that is 10 times higher than the average, just because of the way in which lead appears in soil. And that is why the averaging is appropriate, because individual samples are actually not representative.
But throughout, if I'm, just confirm for me then, but that means throughout the property. If there's hazardous waste, it's everywhere on the property, although there might be variable concentrations in different pockets.
That's
Am I
correct.
understanding you?
That's right.
Mhm. Okay. So any concentration could indeed result in the disbursement of the lead.
Certainly, and that is why the mitigation measures are imposed, one, to prevent the creation of dust to begin with, and that is why the soil will be saturated. The DOH also addressed other exposure pathways, such as migration of dust, and that is why it required the covering of the trucks and the cleaning of the cars that are leaving the site.
Counsel, as part of this process or another that you're aware of, during this construction, will tests be taken periodically of the levels?
In DOH's approval of the construction permit, they specifically stated to the developer that DOH retains authority to do on-site visits and inspections and require remedial measures if any violations are found.
Including this particular issue, lead dust?
If the lead dust if the measures are not being complied with, DOH would be entitled to ensure that they are being complied with.
But I guess that's really not my question. My question is, forget the measures, are they entitled to go in, or are there scheduled periodic tests of what the levels are during the course of the project?
The RAP has contingency plans if there are heightened levels of contaminants that are found in the soil as the project is happening.
I guess
Thank
the
you.
question is, I'm sorry, may I?
Yes.
Just to follow up on Judge Garcia's point, how will you know if they're elevated? At the end of the day, how do you know?
Mr. Greenberg may be better
Okay,
able to
fine. Thank
answer
you.
what the procedures are on site.
Thank you, counsel.
Thank you very much.
Mr. Greenberg.
May it please the Court, Chief Judge DiFiore, members of the Court. I'd like to, if I might, take up on questions that were asked by Judge Feinman and Judge Stein, which in a sense go perhaps to the heart of this case. I think virtually everything you heard from opposing counsel, virtually everything that's in their briefs totaling nearly 200 pages, virtually everything in the massive administrative record in the 7 amicus briefs, virtually all of it underscore the wisdom of this Court's jurisprudence crafted over 30 years. The hard look standard of secret jurisprudence is about the most settled rule of environmental law that there is. It is understood perfectly well by the appellate divisions. It is applied predictably and consistently, almost always by the trial courts. And fundamentally, what that rule requires is the rule of reason, deference. Judge Stein is quite right. The review needs to be meaningful. But nevertheless, what the rule does not require is to turn appellate courts, appellate divisions, this court, into juries negotiating and adjudicating battles of experts. The importance of that rule, this court over and over, starting in Jackson, through Akpan versus Koch, through Save the Pine Bush, over and over, has counseled the lower courts. They must apply the rule of reason and deference. Why? Why has that rule been settled for 30 years? Well, one, the court instructed the lower courts because after all, it is the lead agency's responsibility, not the courts, to comb through thousands of pages of documents, to engage consultants, to have expert analysis and discussion. Consider this case, for example. This case, unlike almost any secret case this court has ever heard, doesn't involve a town board or a city council or a zoning board. This case involves the preeminent public health agency in the state of New York and arguably the nation, the preeminent environmental conservation agency, not just in this state.
What if there was an allegation that somebody was paid off here by somebody, and therefore they took the word of a particular expert over another expert? How would that be borne out? How would that be reviewed? How would that be dealt with?
If there was a credible allegation of a bribe of one of the consultants, that would be a very, very different case. And I don't think it would threaten the stability and predictability of the hard look doctrine, such that you have the city of New York's coming before this court, begging this court, please don't change the settled principles that the compliance with the secret manual are necessary. The real estate board of the city of New York, which is more expert than anyone one could imagine in terms of economic development projects, particularly in the city of New York, is pleading with this court, don't alter the hard look doctrine. However much opposing counsel may profess, oh no, we're just asking you to apply the hard look doctrine, Justice Slobis, while I believe she erred with commendable candor, acknowledged there was a hard look. There was a comprehensive investigation of evaluation of all the issues.
So in that hard look, Mr. Greenberg, you would agree that the exposure of children to lead dust is damaging, correct?
I'm so glad you asked that question. That is precisely why the standards that were applied by the Health Department, a public health agency that cares deeply in its core mission about children and potential risks of lead, applied the National Ambient Air Quality Standard. Why that standard? Because that's the standards to use to protect sensitive populations like children. That's why the Department of Health applied the federal US EPA lead hazard standard. Why that standard? Because that's the standard that's used to determine whether lead where? In playgrounds where children are. So it's absolutely a vital environmental concern. And I must say there's an absolute unreality with opposing counsel's argument. They're suggesting, oh no, nobody really knew there were kids at PS 163. There were 3 days of administrative hearings in this case. Where were they held? At PS 163. Do a word search of the final environmental impact statement. See how often PS 163 is mentioned. Almost 400 times.
No, well, I understood their argument to be that the methodology that was used underestimated two things. First of all, the concentration of lead dust, and second of all, the actual migratory path of that lead dust into the school, into the area, but really into the school. And as a so there's that problem. And as a consequence, the mitigation measures are insufficient. They don't get the job done. So on the first part, what's the response to that?
Your Honor, your question highlights exactly what is at stake in this case and what is at risk if the court would even entertain that argument. Yes, that's what their experts say. And the consultants relied on by the Department of Health said something different. Our trial courts and articles...
And the answer is that that's what they claim, but you've got experts on the other side that say otherwise, court has to step back because the agency gets to decide which expert to rely on.
And it's more, well, in sum and substance, yes, but it's more than just because deference. There are reasons for the deference, and the reasons go beyond simply the expertise, in this case of the Health Department and DEC. The reasons go to what I think the Real Estate Board in the City of New York said, which is the predictability of the doctrine. If you were to authorize lower courts to use what Judge Lobis called the hard enough look standard, if you authorize that, secret reviews will turn into battles of experts. These are Article 78s on cold records. Are we going to have trial courts bringing in experts on both sides and trying to figure out in these highly complex and technical matters who's right and who's wrong? New York is proud of its history and tradition of having amongst the most robust environmental laws and regimes in the nation. We are proud of it. No one has ever looked at the secret doctrine or the immense...
What about the point, I know your red light is off, if the chief will permit me this one question. What about their point related to the construction noise that they say, that, look, the windows have got to stay open to ventilate this building. So on the noise, it's also about the dust, but it's really about the noise. They say that the mitigation measures of just giving us more air conditioning units for the windows that don't have them is not good enough. How does that satisfy the hard look and doctrine? If it, right?
And frankly, why their position reduces to near absurdity, because here we are in the state's highest court, amongst the 16 arguments that they think you should address seriatim is that one, and they would have you sit and try to figure out, oh, is central air conditioning any better or worse than, oh, window air mounted conditioning? I don't mean to trivialize.
No, but their argument is that your assumption about the windows is the problem. Not that window air conditioning could work. I don't think that's really where they're going with that. Their argument is, well, if we could leave the windows closed and turn on the air conditioners, that would perhaps work, or you get to choose, DOH gets to choose. But we can't do that, and that's where DOH...
So let's apply the rule of reason, the rule of pragmatic reason this court has insisted be applied. Are we really prepared to believe that in the midst of construction, that all of a sudden school teachers are going to pop open the windows and not rely on the window air-mounted air conditioning? Are we really to believe that? By the way, you can take notice that in the city of New York, where there are innumerable elementary and high schools constructed in the turn or in the middle of the last century, that window air conditioning units are widely used with little difficulty. That's why the appellate division ultimately concluded it was reasonable and rational for DOH to accept that mitigation measure.
Thank you,
For all
Mr.
of those
Greenberg.
reasons, we ask that you affirm. Thank you.
Counsel?
Thank you, Your Honor. So I'd like to begin where Mr. Greenberg left off, which is what is the standard of review this court applies? And a hard look standard, in their view, is blind deference. It is to ignore what is actually written in the final statement and simply assume that the agency considered the issues presented. I urge the court to look at the final statement here, starting with...
But isn't it more than that? I mean, we do have this record. We can see that there were discussions of these issues. It wasn't that they were overlooked. And I know that looking isn't the same as hard look, but doesn't that get us into a hard enough look? Isn't that what you're saying? So if we see, yes, they seemed to really investigate and they accepted expert advice and so on and so forth. I think, as I understand it, their position is that's as far as we go.
And I understand that to be their position, Judge Stein. And to be frank, I don't understand what the difference between a hard enough look and a hard look is. I mean, that's what we're trying to figure out here, whether there was a hard enough look. But take, for example, lead dust. Look at the actual final statement on lead dust. It never once mentions PS 163 students. Despite a whole section on noise specifically addressed at PS 163, it fails at step one of the hard look process. It does not identify that PS 163 students, 600 students, 30 feet from a construction site, could be exposed to lead dust. If that doesn't
a function somewhat of the risk, right? If you have lead dust and you're doing containment measures, then you're getting it at the source, as discussing before. Noise is traveling, and you have to look at where that noise is going to impact. So you're looking at the school and in the classroom. But on the other side, they're looking at a containment policy. And in the noise, they're looking at a mitigation policy that's on site at the school. So you're kind of comparing two different risks there and saying they did one thing here and one thing in the other side, but they have to address each risk based on what the perceived threat is, right?
Absolutely, absolutely. But look at what the seeker manual requires, and that is for hazardous materials on page 12-14 to consider occupants of adjacent properties who may be exposed to hazardous materials. For example, contaminated soil or dust may be transported to adjacent sites.
But let's say in a hypothetical, you are able to contain 100% of the dust. Do you then have to go to each site that's not this building and say what would be the impact on that site?
No, Your Honor. This is context specific, and the agency has to explain its process. So if the agency said in the record, we have 100% containment and therefore we're not going to consider adjacent sites, that would be something the court could defer to. There is nothing like that in this final statement, and that is why there is a legal hard look error that if this court does not correct, will turn the substantive requirements into
Aren't
secret.
they in effect saying the amount of dust that's going to escape the site is below the level? So wherever that's going from here, it's not going to rise to a level of a risk.
The levels only addressed soil and air quality, that is ambient air in the Upper West Side. But as the statement and the secret manual notes, ingestion pathways, and as this court has noted in Vallone, the ingestion of lead dust is the primary risk exposure for children, particularly children 30 feet away.
But the source is exactly what you've already pointed to, right? The actual site, what happens during excavation, that it gets dispersed, you break through, it gets dispersed, it gets tracked out on the trucks or on people's shoes or whatever. And that's what the mitigation measures are exactly keyed to.
Right.
To address the potential for escape.
And what I'm asking this court to do is not what Mr. Greenberg suggested and weigh all this evidence and come to its conclusions. I'm asking it to enforce the hard look standard, that is, force the agency to explain these things on the record and say the ingestion pathway comes from the same site, and based on existing studies and data, we believe it's
But isn't that obvious?
It's not obvious, Your Honor.
Why is that not obvious?
Because
You're
as this court
excavating in an area that, let's say for one moment, everyone agrees has a certain potential level of hazardous material that includes lead. Lead dust is, of course, a carcinogen, and it has other terrible impacts on children and adults. And that's what you're trying to avoid, migrating off this site.
That's right, Your Honor. And there's nothing in the record that explains how dust will migrate to the school 30 feet away. It's not obvious, and it's not comparable to the NAAQS ambient air quality standards that were actually adopted in the statement. And if I could just briefly address noise with Your Honor's indulgence.
Please.
I would just note that counsel for the Department of Health stated that nothing in the record clued the department into the fact that central air conditioning was needed here. I would again urge the court to actually look at what was before the department. We submitted 3 expert reports during the comment period that stated over and over that that included calculations from the city mechanical code that said central air conditioning is what is necessary to provide adequate fresh air to 30 students in a small classroom. And so the fact that
Doesn't it also have to be feasible, and there are some other reasons why central air seemed to not, that DOH chose not to pursue that as a mitigation measure?
feasibility is definitely part of the analysis. That analysis was not conducted here. And again, that is why there is a hard look failure. The only feasibility discussion was in the post-statement findings, which is what the appellate division used to reverse Justice Lobis. That was a procedural violation. A department can't cure a defective final statement by adding new conclusions to the post-statement.
Is that a
The
timing
agency
issue?
I'm sorry.
Was that a timing issue? Was that raised by you in a timely way?
So we raised air conditioning from the very first impact statement. As the court noted earlier, it's not the commenter's burden to basically redo the analysis and explain how exactly it would work. At the third comment statement, in an effort to convince the agency this was an issue it had overlooked, we noted that it was feasible to install this. If the department decided it was time to address that issue, this court has reiterated in cases like Bronx Committee that the proper procedural mechanism is to prepare a supplemental statement.
Thank you, counsel.
Thank you, Your Honor.
So,
Can I just pick up from there? Because as I see it, as far as the air conditioning was concerned, it was raised earlier on, it wasn't addressed, but am I not correct that the agency doesn't have to address every proposed mitigation measure?
yes,
Okay.
that's correct.
And so then what happened was they didn't address it. It was raised after the FEIS, and then they did address it, right? You're not talking
Well,
about that.
air
Okay.
conditioning is,
Go ahead, never mind.
my overriding point, I think, is that this was not a good faith investigation. I'm not alleging there was bribery here, but I am alleging that this was biased and result-oriented, and I think that jumps out from the page. And so, we believe the seeker manual was not followed, and it cannot simply be that if you cross all the Ts and dot all the Is, go through the motions, that's it automatically. I mean, in the first department, that seems to be the case because, as far as I can tell, although the city did cite one case in its brief, maybe that one of the develop, don't destroy Brooklyn cases, where maybe they did invalidate for failure to take.
Counsel, let me ask you
yeah.
this. Let's go with where I think you were going. So they follow all the procedures. Now you're really talking about the substance. So you've got experts that say one thing, and you've got the public that prefers particular mitigation efforts, and they have experts that say something else, and they decide that other mitigation efforts address the concerns.
Yes. So,
Doesn't the case law say that that's it for us?
well, not
How are
necessarily.
we,
No,
you're
Your
asking
Honor.
us now to be
I believe under.
the supervisors of DOH.
Well, DOH may be the premier health agency in the state, but nevertheless, sometimes there could be biases in government. I mean, I don't know, I was a government lawyer for years, but,
No,
you know,
but
it
let's
does
go-
happen.
Yes, I understand your point on that. I'm not talking about corruption or particular conflicts. I'm not asking you about that. I'm talking just, you've got experts on one side, you've got experts on the other
Right.
side.
But
Isn't that then for DOH, the agency, to decide which experts they find compelling and how to respond to whatever the experts raise for them?
But this is not, this is a matter of common sense and blatant violation of the seeker manual. I mean, the most obvious one is, and I believe, Judge Fay, I think you're correct that, the key thing is, if you look at these soil borings, they took 8 soil borings. The seeker manual says that to assess the hazards on the site, you look at the top 2 feet and the bottom 2 feet, and you analyze those, and then you average. But what they did was, in addition, from the same boring, so without adding any additional information, they took a mush of the top half and the bottom half, which I guess they're, in more technical terms, you'd call a composited sample. But it's a mush, and it dilutes anything that's in there, and they themselves said they didn't do it, they wouldn't do it, they shouldn't do it, and yet they did it. If you look at page 1058 of the record, that's where the Phase 2 environmental site assessment of AKRF is. And there they said they distinguished between those samples that were to be analyzed to guide proper waste disposal, and the other soil samples, which were to be analyzed to assist in the development of appropriate procedures to prevent unacceptable exposure to site workers and the surrounding community. So clearly they took one set of samples for one purpose, another set for another purpose, and they weren't supposed to use the first set to assess the hazards, but when they found the results weren't low enough, they added them in. So if you look at, they themselves said on that page, we didn't do that. And yet, if you look at the tables, it's table 3 of the phase, I think it's at page 1064, I believe. But anyway, it's table 3. It's somewhere right after page 1058. There's a table with the 38 samples, and the waste characterization samples are in there, and they added them in, even though they said they weren't going to do it. So it doesn't take an expert to see that this is not in good faith. To say nothing of the DEC letter, which they cite 10 times, where the goalposts were so obviously moved. So I don't think
We understand your point, sir.
Okay, thank you, I'm sorry.
That's okay.